If you can remove these handcuffs, I'll withdraw the sentence.
You asked for it.
The courtroom of Harlan County, Tennessee, had always been the kind of place that reminded certain people, the wrong kind of people, the out-of-place kind, that they had wandered somewhere they did not belong. The oak paneling on the walls was dark and heavy, the kind of wood that absorbs light, the way old institutions absorb accountability. Completely, without apology, the smell of industrial floor wax and yellowed paper hung in the air like a permanent decree. Most of the people who moved through that space, clerks, attorneys, the occasional journalist from the local weekly, carried themselves with the ease of those who had never once had to explain themselves to the room. She walked in at 8:47 in the morning. Nobody looked up. Why would they? She was a young woman of 29, small-framed and deliberate in her movements, with deep brown skin and black hair pulled into a plain bun at the base of her neck. She wore a white cotton blouse pressed by hand, a grey skirt purchased at a second-hand shop on the edge of Nashville, and a pair of brown leather shoes that had long since surrendered their shine. She carried a cardboard folder, not a leather briefcase, not a professional document bag, but a cardboard folder, the kind sold at corner stationery stores for $3.99, tucked under her left arm. Her name was Amara Osei Bonsu. In that courtroom on that October morning, she was invisible. The clerk behind the desk gave her half a glance and returned to his screen before she reached the counter. A young female intern, barely 6 months out of a community college paralegal course, waved vaguely toward the gallery benches without looking away from her phone. A bailiff walking the aisle passed her the way people pass furniture they have memorized, present, acknowledged by the body's automatic navigation, and immediately forgotten. None of them knew. None of them could have known, but to understand what happened that morning, what truly happened, what the official court record captured in dry procedural language, and what the official court record could never fully convey, you have to begin far earlier, because every story of justice begins long before the moment justice finally appears. Amara was born in Kumasi, Ghana, the second child of Kwabena Osei Bonsu, a carpenter who worked 6 days a week and kept his tools cleaner than most people keep their homes, and Abena Osei Bonsu, a primary school teacher who believed, with the quiet conviction of someone who had tested the theory across 30 years of classroom experience, that the single greatest act of rebellion available to the poor was literacy. The family was not wealthy. They had a small concrete house with a corrugated metal roof, a refrigerator that groaned through the night like an old man with back trouble, and books on every surface, books stacked in corners, books used as doorstops and coasters, and on one occasion that Abena never fully forgave, as a makeshift stepping stool by her younger son who wanted to reach a mango on the kitchen shelf. The books were not luxury, they were infrastructure. From the time she was 4 years old, Amara demonstrated something that her neighbors would eventually call strange, and her teachers would eventually call disruptive, because mediocre teachers have always called disruptive the things they cannot categorize. What Amara had was pattern recognition at a level that existed outside the standard spectrum of childhood development. She did not merely absorb language, she mapped it. She heard the architecture beneath the words, the way vowels shifted weight across a sentence, the way certain consonant clusters identified not just a language, but a region, a social class, a generation. By the age of 6, she moved between English, Twi, and Fante, the way most children move between rooms in a familiar house, automatically without thinking, adjusting posture and cadence, and register as the context required. At 8, she had added Hausa, picked up from the merchants in the central market who conducted business in a blend of languages that most adults found exhausting and Amara found magnetic. At 10, basic Arabic from the religious studies teacher at the public school, a patient man named Ibrahim, who recognized in her the particular hunger of a mind that has found its food and cannot be made to stop eating. By the time she was 18, Amara Osei Bonsu spoke 12 languages. She had won regional linguistics competitions, received commendations from professors at the University of Ghana, whom she had never officially studied under, and developed what she would later describe in the thesis that would define her academic career as an intuition not merely for what language says, but for what language conceals. She had also watched, from the corner of a crowded courtroom in Accra when she was 15, as a cousin named Kofi was convicted of a theft he had not committed. The defense attorney, paid for by the family at the cost of 3 months of careful sacrifice, had stumbled over procedural terminology, confused the burden of proof standards, and failed to challenge a translated statement that bore only a passing relationship to what the witness had actually said in Twi. Kofi spent 2 years in a prison that returned him altered in ways the family only understood slowly. The way damage reveals itself in weight-bearing structures, not all at once, but over time in the places meant to hold the most. The error was not Kofi's, it was the language, the absence of mastery over it. Amara made a promise, not aloud, not formally, but in the way promises made at 15 tend to be the most lasting kind. That she would learn the language of power, every register of it, in every tongue in which it was spoken. When the scholarship envelope arrived at the family house in Kumasi, a thin envelope with a slightly mangled corner where the postal sorting machine had not been gentle, Kwabena wept in the bathroom, with the water running so that no one would hear. Ebena made jollof rice with chicken, the dish reserved for occasions that happen once in a generation. Amara packed 2 bags, left one with her mother because the second was too heavy for the overhead bin, and boarded a plane for the first time in her life. Vanderbilt University in Nashville, Tennessee was not a place built for Amara Osei Bonsu. This was not a conspiracy. It was simply a fact in the way that certain architectural spaces are facts, designed for specific proportions, specific assumptions, specific default human types, and requiring of everyone else a continuous low-grade translation effort that the people for whom the space was built never notice because they have never had to perform it. She noticed. She catalogued. She adapted. She did not complain. This was her first defining characteristic, the categorical refusal of self-pity as a coping mechanism. She had watched it consume too many people, reduce them to the size of their grievances, make them legible only through their wounds. She had other plans. She worked weekends at a restaurant near campus, washing dishes first and later waiting tables, learning through proximity the precise inflections of Mexican Spanish spoken in a Puebla kitchen by cooks who were, to most of the restaurant's clientele, decorative invisibles. She studied Japanese on Wednesday evenings with a retired Kyoto University professor who ran a volunteer language circle at the Nashville Public Library, and who told her, after 6 months, that she had the best pitch pattern memory he had encountered in 40 years of teaching. She learned Hindi through streaming television, replaying dialogue until the rhythmic structure was as familiar as breathing. She pursued a degree in applied linguistics and comparative legal studies, and she pursued it with the kind of ferocity that professors either champion or fear, depending on whether they feel their own limitations are being quietly measured. In 4 years, she had added 9 languages to her 12. 21 total. But what no one knew, what she had carefully chosen not to broadcast, because she had learned early that certain forms of competence trigger certain forms of threat in people who feel entitled to their assumptions, was the specific focus of her specialization. It was not literature. It was not diplomacy. It was not international business, which is where the department career counselor kept suggesting she direct her energies. It was legal language, Specifically, the study of how legal language, in every jurisdiction she could access, in every language she could learn, was structured to serve those who already held power, and how that structure became most destructive in the moment of translation, when a life handed over to an interpreter was a life balanced on the precision of a single word. Her master's thesis examined linguistic dehumanization in judicial documents produced during colonial legal systems, a work that earned publication in 3 peer-reviewed international journals and exactly 0 interest from the academic advisors who were supposed to help her leverage it into a doctoral position. She received a warm letter suggesting that career opportunities in this particular specialization are limited and that she should consider a more market-responsive trajectory. She considered it. Then she went to the field. For 4 years following her master's degree, Amara worked as a volunteer interpreter and informal linguistic consultant for immigrant rights organizations operating across Tennessee. She could not charge. Her work visa was still processing through a bureaucracy that moved with the particular slowness of systems that have never been required to account for their delays. But she showed up. Every time someone needed a voice in Farsi, or Wolof, or Tagalog, or Brazilian Portuguese, or Quiche, she showed up. It was through this work that she found Harlan County. Harlan, in recent years, had become a quiet but significant destination for undocumented workers from Guatemala and Honduras, drawn by labor recruiters representing agricultural and mining operations in the eastern Tennessee interior. The industry had been partially revived through state-level economic development programs. The workers came by the dozens, then hundreds. Most of them under contracts that they could not read, had not had translated for them in any meaningful sense, and that contained provisions for wage deductions, housing fees, and penalty clauses that left many of them earning less than 40% of what they had been promised. Amara spent 6 months documenting these conditions, alone, with a second-hand digital recorder, a spiral notebook, and the particular patience of someone who understands that the history being recorded matters even when no one is watching. She interviewed workers in Spanish and in Quiche, the Mayan language spoken in the highland regions of Guatemala from which many of them had come, and in Garifuna, the Afro-Indigenous language spoken by communities along the Honduran coast. She cross-referenced their accounts with public records, property filings, business licenses, inspection reports. She identified patterns. She assembled documentation. And through this process, she added 3 more languages to her working repertoire: Quiche, Garifuna, and the specific dialect of Appalachian English spoken in the hollows and communities of eastern Tennessee, which was not a separate language technically, but which Amara treated as one, because every linguistic variant carries within it a system of social power, and understanding who speaks it and how and when is the same as understanding who gets heard and who gets translated into silence. 24 languages. She had told no one in Harlan. The reason Amara was in the Harlan County courthouse that October morning had a name, an age, and a story that was the kind of story that becomes invisible precisely because it is common. Diego Reyes was 42 years old, Guatemalan-born, 10 years in the United States, father of 3 daughters and a worker at Consolidated Mining and Agricultural Services, LLC, a company that operated 3 properties in Harlan County under operating permits signed. This was a fact contained in public records that no one had bothered to look up, by Judge Harold Whitmore in his prior capacity as a member of the county's Zoning and Licensing Board. Before his election to the magistracy, Diego had been charged with assault. The real story was different. After 8 months of wages that arrived partially or not at all, after repeated requests for itemized pay statements that were answered with forms in English that no one translated for him, After a confrontation in which he had asked his supervisor in broken but comprehensible English for an explanation, Diego had been struck twice across the face by that supervisor, a man named Brett Calloway, 38 years old, born in Harlan County, who attended the same church as the county prosecutor and had arrived at the emergency room that evening with 2 broken teeth and a fractured rib. Calloway went home the same night without a scratch. Diego was arrested the following morning. The organization Amara worked with had assigned a defense attorney, Marcus Webb, 27 years old, 3 years out of law school, earnest and overworked in the way that young public defenders across the American South tend to be earnest and overworked, carrying 14 active cases with the focused exhaustion of someone who has made a moral commitment to work that the economic structure does not support. Marcus had asked Amara to attend as an auxiliary interpreter. The court's official interpreter, a man named Gerald Finch, 61, certified in 1987 through a program that had since revised its standards 3 times, had demonstrated, across 2 prior preliminary hearings, a talent for translation that was somewhere between inadequate and actively distorting. The discrepancies were subtle enough that no one who was not bilingual and legally literate could easily identify them. But Amara had identified them. She had documented 6 of them. She had not yet told anyone what she planned to do with that documentation. What no one in that courtroom knew, not Marcus Webb, not Gerald Finch, not the bailiff who barely registered her entry, not even Diego himself, was the full scope of what Amara Osei Bonsu had spent the past 3 months preparing. Judge Harold Whitmore entered at 9:12, 15 minutes past the scheduled start, without explanation or acknowledgement of the delay. He was 61 years old, with white hair combed back with something that smelled faintly of cedar and self-assurance, and the posture of a man who had spent 4 decades in rooms where he was rarely contradicted. He had served as Harlan County judge for 22 consecutive years, elected 4 times without meaningful opposition, sustained by the same network of local business families whose interests appeared with remarkable regularity on the favorable side of his rulings. He looked at the room. His gaze moved across Diego, sitting at the defense table in a collared shirt that was too large for him, borrowed for the occasion, then across Marcus Webb and his scattered papers, then briefly, with the attention given to incidental furniture, across Amara. Then he looked at his documents, and the proceedings began. Gerald Finch took his place as court interpreter. Amara sat beside Marcus, her cardboard folder on the table in front of her, her hands still, her expression neutral in the particular way of someone who has disciplined themselves not to show what they are processing. The first irregularity occurred 11 minutes in. Prosecutor Dale Renfro, broad-shouldered, mid-40s, with the thick local accent that in certain rooms functions as a credential, read from a statement attributed to Diego from a prior interview. The statement, as read, indicated that Diego had initiated the physical confrontation and had threatened further violence. Marcus Webb frowned at the language. It did not match what Diego had told him. Amara looked at Diego. Diego looked at Amara. His eyes said in Quiché what his mouth could not say aloud. He had never said those words. The statement attributed to him bore no relationship to what he had actually said. She wrote on a sheet of paper and slid it to Marcus. He read it, pressed his lips together, and made a note. 22 minutes later came the second irregularity, more significant. Finch, translating a question from the prosecutor, used a Spanish construction that was not merely imprecise, but materially transformative. The prosecutor had asked, "Did you strike the supervisor?" Finch rendered it as something closer to, "Do you acknowledge that a physical exchange occurred?" A distinction that sounds semantic until you understand that in American criminal law, The difference between affirming agency in a strike and acknowledging mutual physicality is, in evidentiary terms, the difference between an admission and a description. Diego answered the question he was asked, which was not the question that should have been asked. Amara wrote, "Material mistranslation, question reframed." I confirmed with Mr. Reyes he did not understand the original question. Marcus read the note, stood up, requested a pause for consultation with his client. Judge Whitmore looked up. His eyes had the quality of a man whose schedule has been inconvenienced. "Counselor Webb," he said, the words carrying the flat authority of someone who issues them without expecting they will be resisted. "We have a docket. Let's stay on track. Your Honor, there's a question regarding the accuracy of the court has a certified interpreter." Whitmore cut across him without raising his voice, which was, Amara noted, the more effective method. If the defense has procedural objections, they can be submitted in writing following the hearing. Marcus sat. His jaw was tight. Amara looked at her folder, then at the judge, then at Finch, who was examining the middle distance with the focus of a man trying not to be examined himself. She knew what was happening. She had been watching it happen in rooms like this for 4 years. What no one in the courtroom perceived, what no one could have perceived from the outside of her composure, was that Amara was not simply recording. She was measuring, timing, waiting for the precise moment when speaking would accomplish what silence had been building toward. The moment came 47 minutes into the hearing, and it came in a form that Amara had not specifically anticipated, though later she would understand that it had been, in some sense, inevitable. Judge Harold Whitmore reached to the side of his main document stack and produced a sheet of paper that was not on the official exhibit list. This was itself irregular. Amara noted it immediately, filed it, moved on. What mattered was what the paper contained. She recognized the language before the first sentence was complete. The typeface, the legal formatting conventions, the specific cadence of German administrative prose. It was all immediately identifiable to someone who had spent 2 years studying comparative European legal texts and who had spent an additional 14 months in correspondence with a retired Austrian professor of jurisprudence who had been, in his prior career, one of the foremost scholars of post-war German immigration law. It was a German court document. Whitmore began reading it aloud, slowly, with the deliberate theatricality of a man performing for an audience he considers incapable of following the performance. His pronunciation was serviceable, well enough for someone who had learned the basics, not well enough to fool anyone who actually knew the language. He moved through the text with a pace calibrated clearly, not for comprehension, but for effect. The effect of a language falling on ears that cannot decode it. The particular disorientation of being subject to words whose meaning is withheld. In the gallery, there were sounds, not laughter, the room was too formal for open laughter, but the tightly controlled variety of amusement that lives in exchanged glances and the suppression of smiles. The prosecutor, Dale Renfro, looked at the window with an expression he was not quite managing to neutralize. 2 court clerks found reasons to examine their paperwork. The bailiff by the door stared at a point approximately 6 inches above everyone's heads. The message was clear, even without being stated. It was the message of a room performing, for the benefit of itself, the demonstration of its own authority over those who could not access it. Look at this woman with her cardboard folder who thinks she belongs here. Look at this immigrant who cannot understand the language being used in the room where his fate is being decided. Look at what happens when people like this wander into places like these. Marcus Webb looked at Amara with an expression that contained an apology he did not know how to deliver. Amara looked at the judge. The judge continued reading. A small curve had appeared at the corner of his mouth, not quite a smile, more the physical expression of a man experiencing the particular satisfaction of impunity. The knowledge that you can do this, that no mechanism in the room will stop you, that the silence of the people you are targeting is the confirmation you require. And it was in that precise moment, that exact, calibrated, documented moment, that Amara Osei Bonsu placed her cardboard folder on the table, rose from her chair, and spoke. She spoke in German, not hesitant German, not the cautious German of a student navigating unfamiliar grammar. She spoke in the precise, unhurried German of someone who had spent 14 months in correspondence with an Austrian academic, who had studied Hochdeutsch pronunciation until the fricatives and the compound constructions moved through her vocal tract as naturally as breathing, who had read 400 pages of post-war German administrative law not as an academic exercise, but as professional preparation for a moment that might come. This was that moment. "Your Honor," she said in German that the judge could not fully follow, but could recognize as superior to his own. "I can continue in German if that is your preference. However, I must advise the court that the document you are reading is a decision from the Administrative Court of Frankfurt, dated 1953. It was nullified by amendment in 1961. It has no applicable authority in American jurisprudence, and the interpretation of immigration rights it contains was explicitly superseded by the Geneva Convention of 1951, to which the United States has been a signatory since 1968. The silence that fell over the Harlan County Courthouse in the following seconds was the specific silence of structural failure. Not the silence of a room pausing to process something unexpected, but the silence of a room in which the floor has just revealed that it was never as solid as everyone had agreed to believe. Judge Harold Whitmore did not move for 4 seconds. Amara counted them. It was a habit she had developed studying the pauses in legal proceedings, the involuntary hesitations that reveal more than any planned statement. Then he said in English, with a voice that had lost its first layer of texture, "Who are you?" And Amara answered, still standing, with the posture of someone who requires no permission to occupy the space they are in. "My name is Amara Osei Bonsu. I speak 24 languages, including German, Spanish, Quiche, Garifuna, and American legal English. I am present as an independent linguistic observer and advisory consultant to the defense. And with due respect to the court, I would request that the record of this proceeding be formally suspended until the translation irregularities documented in the past 47 minutes have been reviewed." Renfro stood. "Your Honor, this is entirely Mr. Renfro." Amara's voice did not rise. It did not need to. There was something in its quality, the quality of a voice that has spent years learning exactly how much weight each syllable can bear before it requires reinforcement, that filled the space without competing for it. "I can place into the record, specifically and sequentially, the 6 instances of material mistranslation produced by the court's official interpreter during this proceeding. 4 of them alter the evidentiary weight of the defendant's responses. 2 of them, under applicable Tennessee rules of evidence, may constitute a violation of the defendant's Sixth Amendment right to adequate interpretation. I am prepared to provide the original Spanish phrasing, the translations as rendered, and the accurate translations with citations." The court reporter had stopped typing. The 2 clerks who had been exchanging knowing glances were now studying the grain of the oak paneling with the intensity of archaeologists. Marcus Webb, 27 years old, 3 years out of law school, carrying 14 cases on too little sleep and too little institutional support, felt something he had not felt in months of this work. He felt that there was someone in the room who knew exactly what they were doing. The recess that followed lasted 52 minutes. In the marble corridor outside the courtroom, under fluorescent lights that had the particular bleakness of institutional lighting everywhere, Amara sat on a wooden bench and organized her documents with the practiced movements of someone who has rehearsed an action until it no longer requires attention. She did not look anxious. She had decided, many years earlier, that anxiety was a form of attention wasted on outcomes that preparation had already addressed. Marcus sat beside her. For a long moment, he said nothing. Then, "You could have told me." "You didn't ask," she said, not unkindly, as fact. 24 languages. 24. "And you're what exactly? What's your actual background?" She looked at him with the steady patience of someone explaining something for what may be the third time in a longer conversation. "I am a woman with a cardboard folder," she said. "For now." Marcus processed this. Then he said, "What else is in that folder?" She looked at it, then at him. "The reason," she said, "that today is going to matter beyond this case." What Marcus did not know, what no one in that corridor knew, including the court staff moving through it with the purposeful busyness of people trying to look unaffected, was that the folder contained 118 pages, that Amara had spent 94 consecutive days assembling them, that she had begun, 3 weeks earlier, a series of contacts that had set in motion a process whose first visible consequence was already seated quietly in the courtroom's back row, watching. In that instant, for the first time in a long time, everything was about to change, and Harold Whitmore, who had believed for 22 years that the room was his, was about to discover that the room had been listening to someone else. The woman in the back row had arrived during the recess. She was approximately 50 years old, with close-cut grey hair and the kind of composed, unhurried manner that develops in people who have spent careers in rooms where things are carefully not said. She wore a navy blazer over a white shirt, carried a legal pad and a good pen, and had chosen the seat closest to the courtroom's rear exit. Not from lack of confidence, but from professional habit. People in her line of work preferred positions that gave them sightlines to everything and obligations to nothing. Her name was Diane Holt. She was a senior investigator with the Tennessee Attorney General's Office, Division of Judicial Integrity. 3 weeks earlier, she had received an anonymous call. A woman's voice. Careful and precise, with a faint accent she had spent the following days trying to identify. The caller had described in measured and specific terms a pattern of procedural irregularities in Harlan County's court proceedings involving immigrant defendants. She had mentioned names, case numbers, and dates. She had offered, if the office was interested, documentation. Diane had been in this work for 21 years. She knew the difference between a tip and a package. This had been a package. She had done her own preliminary research. What she found had been enough. Now she sat in the back row of the Harlan County courtroom and watched Judge Harold Whitmore walk back to the bench, and she watched the way his gaze moved across the room, checking, calibrating, assessing, and she saw the precise moment when his eyes landed on her and the precise way his posture shifted when they did. He recognized her face. She had appeared before other judges in this circuit. Her presence in a courtroom, unannounced and unofficial, meant something specific in the language of institutional power. It meant that someone had made a call. When the hearing resumed, the air in the room had a different quality. Not the charged, expectant quality of confrontation, but something quieter and in some ways more dangerous. The quality of mutual awareness. Everyone in that room, the judge, the prosecutor, the clerk, the bailiff, the interpreter, now knew that they were being observed by at least 2 people who were paying careful attention and taking careful notes. Dale Renfro attempted to restore momentum. He recalled Gerald Finch to the interpreter's position and began a new line of questioning directed at Diego. Questions about the night of the alleged assault, Diego's proximity to the supervisor, the sequence of physical movements that had preceded the moment Calloway claimed to have been struck. Amara intervened on the second question. "Your Honor," she said from her seat beside Marcus Webb, in the same measured register she had used before, not loud enough to be theatrical, precisely loud enough to be undeniable. "The interpreter has just rendered the question, 'Were you standing close to the supervisor when he fell?' as, 'Did you push the supervisor?' I can provide the original English question, the Spanish translation as delivered, and the accurate Spanish translation if the court wishes to verify." Whitmore looked at her, then at Finch, then, and the pause was long enough that the court reporter's fingers paused above the keys, at Diane Holt in the back row. "The court notes the observation," he said. The volume of his voice had decreased by perhaps 10%. It was not a dramatic change, but in a room where his voice had functioned for 22 years as the primary measure of all other sounds, 10% was audible as a kind of seismic event. "Mr. Finch, please re-render the question." Finch re-rendered it. This time it was accurate, or close enough to accurate that Amara, by deliberate strategic choice, allowed it to pass. She was not there to win every point. She was there to document enough to win the larger argument. There is a significant difference, and understanding it is the difference between someone who fights and someone who prevails. The turn came 38 minutes into the resumed session when the prosecutor called Brett Calloway to the stand. Calloway was everything the room had been designed to accommodate. 46 years old, born in Harlan County, with the physical presence of a man who had worked with his hands and the social ease of a man who had never been required to account for himself to people he considered beneath him. He had chosen his clothing carefully, worn jeans, a plaid work shirt, scuffed boots, the costume of the honest laborer, rather than the industrial supervisor whose salary was 6 times Diego Reyes's contracted wage. Amara noted the choice with the same attention she would have given a word substitution in a translated document. He testified smoothly and at length. His version of events was internally consistent, composed and, Amara could tell within 3 minutes of listening, rehearsed. Not in the crude, memorized way of someone who has been coached badly, but in the practiced way of someone who has told a story so many times that it has acquired the texture of memory. Then the prosecutor, in what Amara would later identify as the decisive overreach of the morning, the moment when excessive comfort in familiar territory produces the error that breaks open the entire structure, said, "Mr. Calloway, can you describe for the record what Mr. Reyes said to you in the moments immediately preceding the altercation? In Spanish, if you're able, so that the defendant can hear it in his own language." It was theatre, the kind that defense attorneys sometimes use and prosecutors sometimes attempt, putting words into the defendant's language to create an impression of fairness while actually constructing a trap. Calloway nodded with the confidence of a man who had picked up Spanish over a decade of supervising workers whose first language it was, and who had conflated functional command with actual fluency. He spoke. The words he produced were grammatically plausible but phonologically wrong, the Spanish of someone who had learned it transactionally, in the specific register of authority over subordinates, without the regional coloring that marks a native speaker's phrasing the way a fingerprint marks a surface. He said that Diego had threatened him, specifically, and here was the error that Amara had been waiting to expose, because it was the error that collapsed the entire constructed narrative. He used a verb form and a sentence structure that existed in Castilian Spanish, the Spanish of the Iberian Peninsula, not in the Guatemalan Highland Spanish, spoken by a man born in Huehuetenango, whose first language was Quiche. Amara rose. "Your Honor," she said, and the room turned toward her with the reflexive attention of an audience that has learned to expect that her interventions are worth hearing. I'd like to place an observation on the record regarding the Spanish phrasing attributed to the defendant. Whitmore looked at her with the expression of a man who is beginning to understand that each time this woman stands, the room shifts in a direction he cannot control. "Proceed," he said. The word had more resignation in it than he likely intended. "The phrasing that the witness just used," Amara said, "reflects Castilian syntactic structure, specifically a conditional construction with the verb amenazar that is not standard in Guatemalan Spanish. A native speaker from the department of Huehuetenango, which is the defendant's region of origin, would not use that construction. The phrasing is consistent with Spanish learned in a supervisory context by an English-speaking American, not with the speech of the person to whom it is attributed." She paused for exactly 1 second. "I can confirm with the defendant in Quiché what he actually said in that exchange. If the court will permit, this would take approximately 90 seconds and would resolve the discrepancy directly." The silence that followed was the kind that happens when a room full of people performs calculations simultaneously and arrives at different conclusions about what is expedient. Renfro stood. "Objection, Your Honor. The defense consultant is attempting to—" "I am not a defense witness," Amara said, calmly and immediately, not loudly enough to be rude, and precisely loudly enough to preempt. "I am a certified linguistic analyst and independent court observer. What I am offering is not opinion testimony. It is phonological and syntactic analysis, verifiable by any qualified expert in Guatemalan Spanish dialectology. If the court prefers, I can request that a formal expert opinion be obtained through official channels. That would require a continuance. I believe it is in the interest of all parties to resolve this now." Diane Holt, in the back row, wrote 3 lines on her legal pad. Judge Whitmore called a second recess, 28 minutes. He left the courtroom accompanied only by his personal secretary, not the prosecutor, not the clerk of court, not the bailiff, and he was on his phone within 45 seconds of clearing the door. Amara knew this because she had positioned herself near the corridor window and could see the reflection. She used those 28 minutes precisely. She approached Diane Holt. The 2 women sat on the bench along the side wall of the courtroom, the bench reserved for overflow gallery seating, made of the same dark oak as everything else in that building, absorbing the same institutional light. Amara opened her cardboard folder and placed between them, without preface or explanation, a selection of documents. Not the entire 118 pages. "Not yet, not here. Enough," Diane Holt read. She was a fast reader with the particular focus of someone accustomed to identifying significance in dense material. She read for 11 minutes without speaking. Then she looked up. "These translation comparisons," she said, "they've been validated by 2 independent experts, a professor at the University of Tennessee Department of Modern Languages and a certified legal translation consultant based in Atlanta. Both have signed statements, both are notarized, and the business license connections, public record, Harlan County Clerk's Office, pulled directly. The video depositions, 23 workers, filmed over 94 days. I translated each one personally. The documents include both the workers' original statements in their native languages and the versions produced by the court's official interpreter when those same individuals attempted to file formal complaints. The comparison is—" She paused, and for the first time something moved across her face that was not composure. Something that was closer to the specific sorrow of someone who has spent months documenting preventable harm. The comparison is not ambiguous. Diane Holt closed her legal pad. She looked at Amara for a long moment with the expression of someone who has been looking for something and has found it in an unexpected place. "You know what happens when I take this to the office. I have a general understanding. It could take months. I know." Amara looked at the courtroom doors. But Diego Reyes shouldn't have to wait any longer than today. Diane Holt considered this. Then she said with the flat precision of someone stating a conclusion rather than offering an opinion, "No, he shouldn't." When Whitmore returned to the bench, something had changed in his bearing. It was not defeat. Men who have held unchallenged authority for over 2 decades do not put defeat on their faces, not immediately, not in public. It was something more precise, the specific rigidity of a person who has realized they are being watched from an angle they had not accounted for, and who has not yet determined what the correct response is. He sat. He looked at his papers. He looked briefly at Diane Holt. He did not look at Amara. "The court," he said, in a voice that had recovered some of its volume but none of its former texture, "recognizes that there are outstanding questions regarding the adequacy of translation services in this proceeding. Given the technical complexity of the issues raised, the court is prepared to—" "Your Honor." Marcus Webb was on his feet. He was holding a document, a formal motion, prepared in the minutes of the recess on his laptop and printed on the courthouse's public access printer, based on instructions Amara had written for him on a single sheet of paper while Diane Holt was reading. "The defense moves formally for dismissal of all evidence gathered in prior hearings on the grounds of a due process violation. Specifically, systemic interpreter failure resulting in material alteration of the defendant's recorded statements. Additionally, the defense requests immediate conditional release of Diego Reyes pending review." The motion was 3 pages. It cited 7 cases. 6 of the citations had been written, with case numbers and jurisdictional notes by Amara. Renfro looked at the motion, then at Whitmore. His expression was that of a man who had expected to win a game and has just been told the rules had changed before the final point. What no one in the room knew yet, but what Diane Holt had confirmed by text during the recess, her phone silent but screen-lit in her jacket pocket, was that the Attorney General's office had already opened a preliminary review file on the Harlan County Court's interpretation services. That file had been opened at 10:47 that morning, while Whitmore was on his phone in the corridor, based on a formal notification sent the previous evening, and that a journalist from the Nashville Tennessean had received that same morning an envelope postmarked 3 days earlier containing copies of the same documents now sitting in Diane Holt's notebook. The machinery had been in motion for weeks. What was happening in that courtroom was not a beginning, it was a culmination. Harold Whitmore looked at the motion. He looked at Renfro. He looked at the room with the particular attention of a man who has spent decades reading power dynamics in spaces he controlled and who is now reading a dynamic he does not recognize. "The motion," he said, "is accepted for review. The defendant will be transferred to supervised release pending the outcome of procedural assessment." A pause that lasted just over 2 seconds. "Hearing adjourned until further notice." Diego Reyes walked out of the Harlan County Courthouse at 2:23 in the afternoon. It was not full freedom. There was still a process ahead, reviews, filings, the slow institutional work of dismantling what had been built against him. But he walked out, in his own clothes, wearing his own shoes, moving under his own authority. His wife, Eleanor, had driven from Nashville that morning on the specific hope that something might change. Not confident hope, not the comfortable hope of someone who expects the world to behave correctly, but the fragile, persistent hope of someone who has already seen the world fail and shows up anyway, because the alternative is to stop showing up. She was standing in the parking lot in the thin October sun of eastern Tennessee when the side door of the courthouse opened. She ran. Amara watched from 50 feet away. She did not approach. She did not introduce herself. She did not attempt to make herself part of what was happening between Diego and Elena Reyes in that parking lot. There are moments that belong entirely to the people inside them. And the most important thing an observer can do is understand that they are an observer, present as witness, not as participant. Marcus Webb appeared at her side. He had the expression of someone whose professional training and personal emotional response are engaged in a quiet negotiation. "What happens now?" he said. "Now you do your work," she said. "You have what you need. What about you?" She looked at the courthouse, at the stone steps, at the October sky over Harlan County, which was the same sky as everywhere, indifferent to what happened beneath it, in the way that permanence is always indifferent to the temporary. "I have other cases," she said. "What followed did not happen quickly. Justice rarely does." The formal review conducted by the Tennessee Attorney General's office, completed and published 11 weeks after the October hearing, confirmed that Gerald Finch had produced materially inadequate translations in no fewer than 18 cases across 4 years of service as Harlan County's certified court interpreter. 6 of those cases had resulted in convictions that were subsequently referred for review. 2 were overturned outright. Finch's interpreter certification was revoked by the Tennessee Administrative Office of the Courts following a formal disciplinary proceeding at which he was represented by an attorney whose fees, the county later confirmed, had been paid from a discretionary account under Whitmore's signature authority. The connections between Whitmore and Consolidated Mining and Agricultural Services were investigated in a separate proceeding. The Attorney General's report, issued 4 months after the October hearing, found that Whitmore had maintained a financial interest through a family member's ownership stake, disclosed in real estate records but not in judicial recusal filings, in 2 of the 3 properties operated by the company during years in which the company's operating disputes with workers had come before his court. He was formally notified of a conflict of interest investigation under Tennessee's Code of Judicial Conduct. He announced his retirement, citing health reasons, in a 3-paragraph statement published in the Harlan Weekly Courier 2 days before the Nashville Tennessean ran its full investigative report. 4,000 words. 2 weeks of reporting, and a photograph of the courthouse that had been, for decades, unremarkable enough to be invisible. The headline was not about Whitmore, it was about the workers. Lost in translation, how a broken system silenced immigrants across East Tennessee for years. Brett Calloway was indicted on 1 count of felony assault and 2 counts of filing a false police report. He pleaded to misdemeanor assault, received 18 months of supervised probation, and was ordered to complete 200 hours of community service. Many people, including Diego Reyes, who said so quietly when asked, believed it was insufficient. It was also real. And in the imperfect architecture of actual justice, as opposed to the clean justice of imagined resolutions, real is what you work with. The consolidated company was fined $840,000 for violations of the Fair Labor Standards Act and the Occupational Safety and Health Act, identified through an investigation by the Department of Labor that had been, in part, accelerated by Amara's documentation of worker testimony. A civil suit filed by Diego Reyes and 17 co-workers was still in progress as this account was being written, but the trajectory of the legal landscape had shifted in a direction that was, for the first time in years, not exclusively favorable to the company. Dale Renfro requested a transfer to another district 2 months before Diego's case went to a new judge, a new prosecutor, and a new interpreter. One assigned through the federal court's certified interpreter program, not the county's discretionary selection process. With accurate translation, with Amara's documentation entered into the record, with the medical report from the night of the assault, which had been filed but conveniently overlooked in prior proceedings, the true story became visible. The charges against Diego Reyes were dismissed. Amara Ose Bonsu declined interviews. She declined 3 requests from regional outlets, 1 from a national news service, and a sustained attempt by a documentary filmmaker whose interest in her story she appreciated more than she communicated. Her written responses were courteous, clear, and consistent. The attention should be on the people affected, not on the person who helped. The one journalist who got more than 5 minutes with her was Patricia Wren, who covered labor and immigration for the Tennessean, and who had the particular professional patience of someone who understands that the best sources require the kind of presence that cannot be faked. They met at a coffee shop in Nashville on a December morning, 6 weeks after the story had run, and generated more response than either of them had anticipated. Patricia asked, "Why stay quiet for so long? You had the documentation. You could have brought this forward earlier." Amara thought before answering, not performing thought, actually thinking the way she always did before she used words, because she understood that words are not free. "If you surface before the structure is complete," she said, "they find a way to discredit you before the documentation is irrefutable. When you are who I am, when you carry this face, this accent, this boarding pass from another continent, you cannot give the other side any seam to question. The work has to be airtight, because your margin for error is not the same as someone else's margin. That is not a complaint, it is a condition, and conditions can be prepared for." Patricia wrote that down, then she looked up. "And the German," she said. "In the courtroom, you could have let it pass." Amara was quiet for longer this time. "When someone uses a language as a weapon to humiliate," she said finally, "the correct response is not to pretend you didn't understand. It is to demonstrate with precision that you understood everything, including the intention." There is one detail that was never in any of the reporting. A small thing, carried privately, the kind of memory that belongs to a person rather than to a story. On the afternoon Diego was released, after the Reyes family had gone, after Marcus had returned to his car with his papers and his phone and his next case already waiting, Amara stood alone for a few minutes in the parking lot of the Harlan County Courthouse. It was a Tuesday afternoon in October in eastern Tennessee. The light at that hour in the fall in that part of the South is particular. It arrives at an angle and with a quality that softens the edges of things without removing them, makes the ordinary look briefly like something it will not remain. The trees at the edge of the lot were turning. The mountains visible from the parking lot were the same mountains that had been there before the courthouse, before the county, before the machinery of law and its failures. They were indifferent in the specific way that old things are indifferent. Not hostile, just present on a different timescale. She stood in that light for exactly 2 minutes. She was not celebrating. She was not processing a victory in the way that language about victories tends to describe. It was closer to confirmation. The quiet, internal recognition that what you believed was possible and what a considerable number of voices across a considerable number of years had tried to tell you was not, had in fact been possible. Her phone rang. It was the Nashville office, a Vietnamese family in Knoxville. Asylum documentation rejected on the basis of a translation error that had converted a documented political persecution into a domestic personal conflict. Would she be able to look at the case this week? She looked at the light for 1 more second. Then she answered the phone. 3 weeks later, an envelope arrived at the Nashville organization's office. No return address. Inside, a single sheet of paper, folded in thirds, written by hand in careful English, the English of someone who learned it as a third language and writes it the way you carry something fragile, with extra deliberateness, making sure nothing is lost. It said, "To the woman who spoke German in the court, my husband came home, my children have their father. I do not know how to say what this means in my language because my language does not have a word for it. I only have thank you." It was not signed. Amara read it once, folded it along the original creases, and placed it in the lower drawer of her desk, not in the cardboard folder, In the drawer, the place where things belong to you, not to the process. In the months that followed, the Attorney General's report generated something that Amara had hoped for, but not assumed: structural change. Not dramatic, not immediate, not sufficient. Nothing in this category of work is ever sufficient, but real. The report recommended, as a minimum procedural reform, that all Tennessee court proceedings involving parties requiring interpretation be subject to a dual verification protocol. An official interpreter and an independent certified reviewer with no county financial relationship. The recommendation was taken up by the state's Judicial Standards Committee. 3 civil rights law firms in Memphis, Nashville, and Chattanooga cited the Harlan County case in separate petitions to the Tennessee Supreme Court's Rules Committee regarding interpreter standards. A small correction inserted into the body of a large system with the potential to propagate. This was the kind of outcome Amara worked toward. Not the applause, not the recognition, the propagation, the way a single precise change made at the right structural point can move through a system and alter outcomes for people who will never know the change was made on their behalf and will never have reason to know the name of the person who made it. The following summer, the University of Tennessee invited Amara to deliver a lecture series on language and equal access to justice. She accepted, with one modification. She asked that the first lecture be open to the public, free of charge, and held at the Harlan Community Center rather than on the university campus. The university's events office agreed after some internal deliberation about logistics and anticipated audience. On the evening of the lecture, the community center was full. There were academics and students and lawyers and county officials. There were also workers, some of whom Amara recognized from her months of documentation, others whose faces were new. There was a mother with 2 small children in the back row who had driven from Cookeville specifically for that evening. There was a man in his early 70s who had been in the United States for 42 years and who, at the end of the lecture, stood for a long time against the wall before approaching Amara and saying, in the Spanish of Oaxaca, that he had witnessed a translation error in a Tennessee courtroom in 1989 that had cost his brother 3 years of freedom, and that he had never found the right words for what that had been. Amara listened to him completely, without interrupting, without offering comfort he had not asked for, with the full, undivided attention of someone who understands that some stories require only a witness, not a solution, not a response, not a silver lining extracted from a wound that has not finished closing. When he finished, she said, in basic Zapotec, that she had been learning for 7 months from recordings made by a Oaxacan cultural preservation project she had found through a university library database. I heard you. He nodded and walked away. On the last day of that year, Amara Osei-Bonsu opened a new notebook. She had the habit of beginning each year with a new notebook, not a diary exactly, more a working document, a living record of cases and observations and linguistic structures encountered, expressions without accurate translation in any language she knew, which she recorded because the untranslatable spaces between languages are, she had come to believe, the most honest maps of human experience available. On the first page, she wrote a list. It was not a list of languages she spoke. It was not a list of victories or outcomes or documented cases. It was a list of languages she intended to learn. 7 names, indigenous languages of Central and North America, languages carried by communities that arrived in the United States without documentation, without resources, and frequently without anyone who could meet them in the language in which they thought, dreamed, remembered and understood what was happening to them. Quechua, Mam, Mixtec and Quiche, Cherokee, this one particularly, because Harlan County was within 2 hours of some of the last Cherokee communities in eastern Tennessee, And because she had discovered in her months of field research a pattern of land rights disputes involving community members that rarely reached formal legal channels, precisely because there was no one who could carry the case in the language it needed to be carried in. 7 languages. 24 plus 7 was 31. Amara closed the notebook, turned off the lamp, and in the darkness of the apartment in Nashville, Tennessee, on the first night of a new year, the world continued to be what it had always been: imperfect, unjust, full of rooms where certain people were made invisible by the language of those who held the authority to name things, and she continued to be who she had always been, a woman with a cardboard folder and 31 languages soon, and the patience of someone who knows that the true story is rarely told in the first hearing, but that if you document it carefully enough and build the structure correctly and choose the right moment to speak, it will be told, in whatever language is necessary. Stories like this happen in courtrooms across this country every day, invisible, not because there are no witnesses, but because there is no one trained, patient, and determined enough to document them, translate them, and carry them to the light where they belong. If this story moved you, share it. Because silence also has a language, and the only way to break it is to speak, in whatever language it takes. Subscribe for more stories that the headlines ignore.